from His Excellency the President to also obtain the documents that, Chairman, you directed the clerk to provide, including the Hansard, and you are ruling on jurisdiction. And that is why I'm not addressing the jurisdictional issues. It was raised, we raised it here, you ruled. And that is how the rule of law works. You ruled on it. We ask this committee to please adjourn so that we obtain that. And lastly, Chairman, Standing Order 256A of the National Assembly Standing Orders empowers this committee to go back to Parliament for an extension of time. I know the clerk is next to you, a good friend. He can confirm that. So there is no need to rush. And Commissioner Juliana Cherere stand prejudiced if even the ruling of this honorable committee is not provided the way you directed. The Hansard is not provided. His Excellency says they are rogue. We need further better particulars. I so submit, Chairman.
Thank you. Thank you, Council. I think that was elaborate. You've made your point. But I'm 100% sure that the petitioners who are here and the committee is going to be the last. It's the petitioners really who have direct interest in this. So they are the ones we shall give to make comments on it. But it's good I remind you Standing Order number 67B of our standing orders. In a removal proceedings, a respondent is to be allowed not more than 2 hours. Those are our standing orders. I'm sorry about that, but unless the Speaker sets a further time, this particular time is set 2 hours. You shall have to go by 8, but we also have some discretion to ensure that justice is not only seen to be done, but is actually done. Having said so, we have the senator who is petitioner for the representing the Republican Party. He has a burning issue. Let's hear from the senator.
Chair, let me start with the burning issue. The Constitution of Kenya and the standing orders of Parliament prohibit a discussion of a sitting president on any issue, even the alleged tweets which are not verifiable. That is issue number 1. Issue number 2, my colleague, Apollo Mboya, knows very well when our clients have issues and the matters are of national notoriety, captured in newspapers, dates of hearings given in newspapers, which is a substitute for service to respondents. It becomes incumbent upon an advocate to go to court, which are public offices, walk to Parliament, which is an open Parliament, a public place, seek all that he is alleging to have sought, and he has not been given. Chair, the only issue he has raised, other than the answered reports, minutes, those are issues he might require in case this committee finds the respondents culpable with a prima facie case, and then we move to the tribunal. They might assist him immensely on that. The only pertinent issue, if he had not bothered to have gotten from Parliament, is the petitions, which he feigns ignorance to have, acquired. The petitions. And I don't understand why my colleague of long-standing practice didn't seek to get the petitions. Which petitions the respondents are going to be cross-examined on today. That's what I have to say, Chair.
Standing order number 87. Please, you may have a look at it, honorable members. In as much as we are not admitting any of regarding the tweets and what have you, a mention has been made. Please look at standing order number 87. There is a prohibition on what we can say and what we cannot say, both in the House and in committees, touching on the President, the Speaker, any judge, judicial conduct of any person performing that particular. We are not saying much, but we are saying I think you have to have restrictions because we have it with us. We'll make a ruling on it. But as we continue, let us hear from the other petitioner. Bishop, what is your view as regards the application for adjournment?
Thank you very much, Honorable Chair and members. Honorable Chair, I seek to oppose the adjournment vehemently. And Honorable Chair, asking the Council to conform itself to Article 159, 1B, that justice shall not be delayed. And also, Honorable Chair, the Council is asking for what shall be provided at the tribunal. And at this point, Chair, at this level, the National Assembly is only mandated to find that the petitions disclose sufficient ground. And sufficiency is not adequacy. So the tribunal will do most of the part. And if they are aggrieved by the President's tweet, then I'm sure the President, there can be application for the President to appear at the tribunal. At this point, Honorable Chair, we are asking you that the Council, from the beginning, that they aligned themselves politically, is now finding that the issue of jurisdiction does not hold water whatsoever. He has come here with different antics to trap the committee into certain technicalities that don't hold water in law. Therefore, Honorable Chairman, I ask you that if this is delayed, then justice itself is delayed. And I'm asking this committee to judiciously, please approve these petitions so that majority of Kenyans can then receive justice that is requisite to them. And at the end of the day, we can achieve the strength and the stability that this nation requires. Thank you, Chairman.
Thank you. That's who?
This is the petitioner.
Yes, petitioner. Yes. Thank you very much. Yeah, that's Nelson, and this is Lagat, Geoffrey. Yes. Sorry. Good, I get you. Yes, Nelson. Introduce yourself and let Geoffrey.
For purposes of record, I'm Nelson Mutai for Langat, who is the petitioner. I have instructions to make to this committee. The instructions are as follows: that our client objects to this adjournment, this application for adjournment. It is a tactic that the respondents have chosen to delay and derail the process and the first judicious determination of this matter. In the circumstances, should the committee finds it necessary to adjourn, my client has insisted that the respondents do pay costs of the adjournment. Thank you. My client can say something.
Chair, in addition, this is Langat, the petitioner.
Exceptional, just because you are quasi-judicial, otherwise you are represented, but you may say whatever it is you want to say.
Yes, I'm adding to what my counsel has said, just in addition. I'm very sure my learned senior, Mr. Paul Lomboya, and this client were properly served with the petition. To the best of our knowledge, they have not responded. On 24th, they did not sit in through the proceedings. Actually, they stormed out and they ran away from the proceedings. This committee should take cognizance of the fact that if you choose not to participate in the proceedings, you come back with a delay tactic. You should not be allowed to play around with the committee with a serious mandate to adjudicate on matters of national importance. The issue of jurisdiction was properly dealt with. The information being sought does not help in any way in response to the petition, because at the moment, what's at stake is the petition, no longer the jurisdiction issue. The answer being sought in totality concerns the proceedings over jurisdiction and the ruling. This committee must dismiss the request for adjournment by counsel on behalf of his client, and the delay tactic should be noted. Therefore, I further request for the committee to proceed with its constitutional mandate, conclude the process, and take the necessary steps to bring it to conclusion. Thank you, Chair.
Thank you very much. Really, in my view, the application has been made. It has been responded to. And I think as far as the committee is concerned, that's the farthest it goes. It now has to give a decision. It has to give a decision. So what we shall do is we will retreat for about 10 minutes, sift through everything you've said. Do you wish to respond to any of what they have said? To what the petitioners have responded to you?
Yes,
they haven't said much.
Yes,
really.
They haven't said much.
Yeah.
One sentence. Chairman, the clerk of this August House was directed by this committee to provide what we are seeking. Us, as the advocate, again followed with a letter. They have not been provided. The issue of other petitions, the last one, that have been filed, and the senator asked me why I could not walk in and obtain them. I cannot walk into Parliament Records Office and obtain other petitions. The petitions relating to Juliana Cherera was served. We have it. But we were asking all other petitions that could have been filed. Thank you very much.
Apollo, just in case there is to be an adjournment, how much time are you asking for? Considering that there are set limitations even by the standing orders. So how much time are you asking for?
Chairman, I'm cognizant of the timelines in the standing order. But I also pointed out to you the standing orders that gives the House power to extend the period. And Chairman, I want to go back to our legal practice. The minimum that any person is allowed, even in a court of law, to respond is 14 days. I'm asking for 10 days.
Even in a presidential petition?
Chair.
No. Yes.
That's one.
Even the presidential petition is not 2 days.
We never gave 2 days. We gave 7.
No, not Chairman. Let's get it clearly. The petitioners presented on 24th and 25th. It starts running, the response starts running from the date that the petitioners have presented their case. Yes.
Thank
Today
you
is
very much.
28th.
Just for
Thank
clarity,
you.
please. For clarity, so that we make a
So
sound
how many days are you asking for?
We are asking for 10 days.
Chair.
Chairman, with a rider, that the clerk is going to provide the documents requested and also comply with your own directions, Chairman, to provide the ruling and the answer.
You have had more than 10 days now, as we speak, possibly almost 14 days with the petition. All right? You haven't demonstrated to this, but we need to know exactly how the documents you've related for. The ones you've related to us, how they relate to your defense, that we shall be looking at. Just in case the adjournment is rejected, I'm not saying it's going to be. Are you ready to proceed?
Chairman, will not be ready to proceed in the absence of critical documents that we have asked for pursuant to Access to Information Act and Article 35 of the Constitution, and also pursuant to your own directives.
Chair,
As I posed the last one.
thank you, Chair. Chair, I wanted a bit of some clarity, and as I always say, it's possibly for purposes of jurisprudence. Council, is referring us as to Article 50 of the Constitution on the fair hearing and everything, and is seeking adequate time for that. But he also lives by the fact that we are a quasi-judicial committee, that its roles are limited as provided for Understanding Order number 230, and particularly 4, which is merely investigative. Merely investigative. I mean, one is not placed here for purposes of, he's not accused. That we are not accusers. We are simply listening and investigating. I need him to address us from the point of investigations. I mean, really, we are merely investigating as provided for under Article 230. There is nothing like fair hearing, actually. In any case, we actually provide that time to be had. However, it is simply investigative. How do you relink that between the Article 50 and the Standing Order? Our powers are limited by Standing Order number 234.
Chair, if I may. Chair, Council has alluded to petitions that have not been served upon him. So I'm just wondering, Chair, is Council aware of other petitions that even perhaps this committee is not aware of? Because I believe that matters that should be discussed here are what are within our knowledge and what has been served that are supposed to be responded to. Because, Chair, in all due honesty, even in a court of law, you would not respond to perhaps, let's say, a plaint that you have not been called to respond to.
Chair. Sorry, what you do is, let me stop there. Committee, you may end up discussing your thinking here while we are supposed to retreat and consider this in great detail. Apollo, sir, if you have anything to say, just say it. I'll give them 10 minutes. We come back with a reasoned ruling, at least fairly reasoned. It may not be as detailed, but to cover the points you've raised, so that we are also seen to do justice to this matter.
Chair.
So, do you have any more response to
Chair, I
make?
seek to raise one thing once you give me the permission. Chair, the Constitution envisions unreasonable delay, even if Article 50 is being considered. What Council is asking for is unreasonable delay. Chair, when they were here, when we were providing our petition, they aligned themselves to a political divide that is saying that they will institute chaos as from Wednesday to stop our petitions. And in that line, Chair, we ask you to expedite this hearing so that justice is not delayed and this process is not politically hijacked. We are aware that even Council was consulting with them, and therefore we are asking you that fair hearing will be instituted at the tribunal, and unreasonable delays must be objected and rejected at this particular manner. The role of Parliament is clearly known. Thank you.
We've had your unreasonable delay. The rest of it may be a little bit political, which we may not delve into now. Let's hear him as the final veto, then we retreat.
Yeah. Thank you, Chairman. And I'm not going to be political. I've remained very professional in my presentation, and I've realized that. And the Reverend, when we meet in heaven, we will know whether you are saying the truth, because he has alleged certain things which the Chairman has said I should not even. Now, let me start with Honorable Osoro. Osoro, on the question of fair hearing. Immediately, and take this one to the bank, immediately you say it is quasi-judicial. Article 50 sets in automatically. And there are several court cases on that. Of course, I don't have them here, but I litigate. This is my 22nd year in practice. And in that, my short period of 22 years in practice, I have known that the people who adhere to the Constitution has got longevity, and they outlive those people who don't want to adhere to the Constitution and the rule of law. On the question on your question was on I remember I'd asked a question.
You've alluded to petitions, other petitions.
Okay. Yes, Chairman, I'm a practicing lawyer. I know that there is a case in Kisumu where a petitioner has filed a case, and I think the National Assembly is a party to that suit, that he had filed a petition on, I think, around 25th of October, and the same petition has not seen the light of day. But because it is something that is live in court, I better just say that. And that is why we asked for that question. Give us a list. And Chairman, lastly, the clerk can very well also answer that there is no other petitions. The question would have been answered. But the clerk has gone mute. And under Access to Information Act, it is important that that question is answered when there's a request. Thank you, Chair.
Thank you. Thank you, Council. Thank you, everybody, even petitioners. Just be patient. We will take about 10 to 15 minutes. We'll come back with our decision on how we are to proceed from here. Thank you very much. Just give us the time.